Okay, good evening, everybody out there. I hope that we've all just about signed on time. I know it's sometimes hard to get to the screen at the right time, but welcome. My name is Frank Johnson. I'm the president of the Barbados Autistic Society or Association, rather. And my representation today is that I represent myself as a father of a child who is mildly autistic. So it's good to have somebody here with absolute first-hand experience of these things, about looking after somebody who's disabled. But I also represent the BCD, the Barbados Council for the Disabled. So first of all, I say thank you to them for allowing us to use their conference space this evening. So I'm going to welcome now Mr. Kenneth Pope Law of Ottawa, who is a specialist lawyer in all things to do with estates and the legal side of looking after your dependents once you've disappeared, once you've died. Straight to it. We also have Ken's associates here from Barbados, which are represented by FT Legal, and they will introduce themselves when they come to the microphone to speak as well. So I'm going to say just a few words just to warm us up and just to make allowance for those people who can't be here at the right time. As I said, I represent myself as a father of a disabled young man who's now a full adult. And the point is this: when we talk about children with disablements of either intellectual or physical, we often forget that they don't disappear at the age of 15 or 16 when they leave school. They grow into adults. And when they're adults, they still have to be looked after. They have to be looked after usually on a 24/7 basis. And it is this which, after you have looked after your child for several years, it is this which finally comes to the fore in your mind. The decision of what to do, how to look after them after you've died. It's something which I think about every day, and I know that the very many members of the BCD also have got the same question facing them as well. I'd like to think that at the end of this meeting, I can have enough information in front of me to be able to say there's a chance here to do things different than the age-old way in which people have done things in Barbados for their disabled dependents. For years and years now, the population of disabled people have been passed on to either their siblings or their relatives or friends even. And it is not the most perfect solution at all. It doesn't give you yourself as the parent any kind of real comfort that things will be taken care of when you're dead. And we need a better way to look after our children, to give comfort to us now while we are still alive, with the knowledge that when we die, the children will be looked after. And I keep on saying children, these are adults, these people who are still disabled. And we have to think of them as adults who need all of the things which adults need. And that covers all of the emotional support and all of the physical support. So it is a tall order which has to be sorted out. I look forward to hearing about the legal and financial side of the steps you can take, which can form part of the will that you prepare. And I have been in brief discussion with Ken a couple of days ago, I was told by him that his firm has developed a niche market understanding of this particular issue. So after having said a few words, I'll just say as well, the Canadians always seem to come down into Barbados during January. And I must say that they have excellent timing this time, because on the BBC News this morning, apparently,
you heard about that.
Apparently, Ottawa has disappeared under a white blanket. So something for you to look forward to when you return.
Apparently, we got 50 centimeters, which is about 20 inches.
Yeah, I saw.
It's not equal, not level.
Well, it's not down here, that's for sure. So I'm going to now hand over to Tara of FT Legal to take it from here. And by the way, we are accepting all sorts of questions, so please send them in, and they will be modulated and presented to us during the discussion and after the discussion as well, I should think. Thank you.
Thank you so much, Brad, for that very helpful introduction. I choose, I've taken note that the Canadians spend this time of the year, but we welcome them in any way. Good evening, ladies and gentlemen. By way of introduction, my name is Tara Fraser, and I'm the principal of FT Legal, which is a boutique law firm in Barbados, catering to a wide variety of client needs, including estate planning and conveyancing. I'm an experienced attorney at law with over 15 years of experience working at leading firms in the Caribbean. I have led discussions in various fora on legal issues at various conferences in the Caribbean and Latin America. I'm also the former chairperson of the Barbados chapter of the Society of Trustee and Estate Practitioners, which is a global organization comprised of professionals operating in the trust and estate planning space. It is my distinct pleasure this evening to share a brief introduction to trust and estate planning, as well as to ultimately introduce Mr. Henson, our keynote speaker for this evening. What, you may ask, is estate planning? Estate planning is, having an estate plan is one of the most important things you can do for your loved ones. It is, however, unfortunately, a task that many of us dread and put off dealing with until much later in life. If there's one thing we can recommend, it is that it is never too early to start planning, but it certainly can be too late. Do you have an estate plan that will provide for your loved ones in the event of death or upon incapacity? So essentially, estate planning revolves around making the necessary arrangements so that everything you own or your estate will go to the right people when you die. An estate may include land properties, vehicles, bank accounts, investments, insurance, furniture, jewelry, and any other items of value. These arrangements set forth how you want your assets to be distributed when you pass away and ensure that that sufficient care is taken of your loved ones. If you have any assets and or if you have any children or other dependents, and in the context of this presentation, we are focusing on disabled dependents or children, you should certainly take steps to organize your affairs. There are a few key reasons why you should focus on estate planning sooner rather than later. One, you ensure that your estate will never go to unintended beneficiaries. Naming your beneficiaries ensures that they'll be the only ones who will enjoy what you leave behind. For example, in Barbados, if two persons are cohabiting for over 5 years, they are treated as spouses for the purposes of our succession law. And that person who is the cohabitee will be treated as your spouse for the purposes of estate dispositions. That's really important because not many people are actually aware of that. So again, the main point is you ensure that your estate will never go to unintended beneficiaries. Two, you ensure your family's way of life. Estate planning through investments and insurance provides a financial buffer so that your family can continue living to the standard that you would like them to continue with. Three, you eliminate family disputes. Name beneficiaries and specifying their inheritance can minimize disagreements between family and relatives. And four, finally, you enjoy peace of mind. Having a plan in place means you can sleep at night knowing that the future of your loved ones is safe and secure. comprehensive estate plan can help you feel more confident about the future, knowing that your loved ones will be taken care of and that the legacy you leave behind is the one that you want. Thoughtful planning can help minimize taxes and probate fees and ensure your family will have less to worry about when you are gone. However, failing to make plans for your estate can lead to unintended complications, query 7. As you can see, this is not a straightforward process. It can be complex and it can be tedious, but it's always best to get assistance with a professional. Now, estate planning, as Ken well you know, is actually a wide-ranging process, but there are certain key documents that you want to have put in place in the context of estate planning. One is a will. That is the standard and most basic document that will be created in the context of estate plans. The will names the executor or personal representative to administer the distribution of your assets as you intend. Your will can also appoint guardians of minor or dependent children who oversee their custody and care until they become adults. It may or may not include a trust, which takes effect on your death. So that's a will. Basic starting point for estate planning, entry level. You can take that a step up. You can set up a trust, which can also discuss in more detail here. You can establish a trust which takes effect while you're alive. A trust, in very, very simplified terms, permits assets to be held by one person for the benefit of another. It can dispense with the need for a grant of probate if all your assets are transferred into a trust whilst you're alive. I'll also mention a power of attorney. And I'm mentioning this in the context of estate planning because in some countries, it is possible to create a power of attorney which operates after you die. Unfortunately, this is not the case in Barbados. Barbados actually continues with the traditional, what we call common law English position, which is that the death or incapacity of the creator of the power of attorney will actually revoke that power. So what has happened in certain jurisdictions around the world is that they've actually passed statutes to alter that traditional position to say that a power of attorney will actually continue to subsist after the person who makes the power of attorney dies or loses capacity. In Barbados, that's not the case. We haven't actually made some laws as far as it's concerned. So you actually would need to make an application to the court to have a receiver appointed to manage the assets of that person who is mentally incapacitated. But I'm mentioning the power of attorney because that's something that people often care about and want to discuss in the context of estate planning, but just to give you some context as to what is and isn't possible in Barbados. You may also, in some jurisdictions, you may also have heard of a living will or an advance directive. That's basically allowing you to give instructions as to your end of life healthcare wishes. So if there's a point in which you are you don't have capacity, you're not able to consent, it is basically the directions in advance as to whether or not you will accept or refuse certain medical treatment. Again, this is permitted in some jurisdictions. Position is not entirely clear in Barbados, so it's not likely that a living will or an advance directive will be enforceable per se in Barbados. Now, I'm going to get into a little bit more detail about the concept of a trust. And this is a precursor to Ken's discussion, which is going to go into detail about a lot of the possibilities for planning, particularly for disabled persons, that is possible in Canada. So I thought it would be helpful just for members of the audience to have a deep understanding as to what a trust actually is. So the concept of a trust is not new. It's a creation of English law, of which Barbados law is based, and it has a long and distinguished history harking back to medieval times. I don't propose to do the historical origins of the trust, but it goes back to medieval times where you may have one person going off on a crusade, you need someone to look after his land, or a person who was a member of a religious community, and because of their religious vows of poverty, were forbidden from holding property. So the concept of a trust, it has a long history in law. It's nothing new and fandangled. There's a lot of case law that supports it. It's definitely something that is a trustworthy and safe instrument to consider in the context of your estate planning. Essentially, with the trust, you have a number of characters in this play. You have a person who's called a settlor. The settlor is the person who transfers the property to the trustee to be held for the benefit of the beneficiary. So you have the settlor in the case of our discussion here, that would be the person who's planning their estate, who would actually transfer their assets, which are to be held on the terms of the trust, to the trustee for the beneficiary. So it's basically transferring property to one person to hold for the benefit of another person in highly simplistic terms. And how the law achieves this is by notionally splitting property into two parts. So you have legal title to the property and beneficial interest. The law is saying, here's this piece of land. The title deeds say that this person, that John, is actually the owner of the property. But John is the named person on the title deeds as owner of the property, but John may be holding that property on the terms of a trust instrument. And so Jane could be the person who is entitled to the benefit of that property. Jane is the person that could be entitled to the benefit of that property because the property is split between the legal title and the beneficial interest. So that's how the law notionally achieves this separation. So it separates property into two parts in order to be able to say that one person holds a legal title to the property and the other person is beneficially entitled to the property. The fundamental and primary obligations of the trustee are to faithfully keep within the terms of the trust and to loyally and altruistically further the interests of the beneficiaries. The trustees must act in the interest of the beneficiaries and not for themselves. How are trusts used and what can you do with the trust? The modern use of a trust is wide and varied. It's possible to create a trust without written documentation. It may even be deemed to arise by a court to remedy injustice or unfairness and therefore harking back to its historical origins. So there are many different types of trusts you can use it in a commercial context like pension trust or unit trust. But for our purposes today, we're talking about private family trusts. As a tool for planning in the family context, it's helpful to minimize the effects of taxation, to facilitate the smooth succession of assets to loved ones, and it can avoid the need for probate if all of the assets of the relevant person are actually put into a trust. For the purposes of today's discussion, we're focusing on protecting disabled or vulnerable children or dependents, so on and so forth, even protecting assets against creditors. So there are many different ways you can actually use a trust and many benefits for it. But for today's purposes, we're focusing on protecting the interests of disabled or vulnerable children. You may also query to yourself, can I maintain control in a trust? Because you can actually have a trust in a will. So we spoke earlier about the different levels of estate planning. So you can start at a basic entry-level point with a will, the basic stuff. Everybody should have a will. You can probably take it a notch up and you can have a trust. And there are different things you can do depending on the amount of your assets and the complexity of your family issues. So you can actually create a trust in a will, but that trust takes effect when you die. If, however, you want to create a trust while you're alive, which is what we're talking a lot about today, you may think about things like wanting to maintain control in a trust. Now, I'm not sure how different it's going to be from a family law perspective in terms of the reservation of control by settlers, but certainly from the perspective of Barbados law, there are certain things that settlor can do to maintain some level of control in the whole trust arrangement. You can have a letter of wishes, which actually gives guidance to the trustee as to how you want for your trust assets to be dealt with. You can also have, I'm being told that I'm not being heard very clearly. So forgive the intrusion while we sort some technical difficulties.
That's this one.
This one still seems to be the best.
That's
Oh, that's one.
Yes, that on button.
Let's just test that real quick.
Testing, testing.
Yeah, there we go. That's a lot better. All right, hopefully that's better for everyone.
Yes, yes. Sorry, folks, for that slight interruption. Right, so we've had a basic discussion about different levels of estate planning that you can start at the entry level with a will, which is a basic thing. Everyone should actually have a will in place. And the will is basically disposing of your assets on death. It's revocable while you're alive. You can also have the will containing a trust in that document. But you may also want to think about creating a trust whilst you're alive, which is called an inter vivos trust. Because you're creating a trust whilst you're alive, you're transferring your property to the trustees or the trustee to hold for the benefit of the beneficiaries. It means then that you have divested yourself of ownership and control of that property. So it only works if you're actually properly transferring your property to the trustee. And there are trusts where you can actually be the trustee yourself, but that gets into a level of complication that we don't want to get into for the purpose of this discussion. But if you're transferring your property to a third party to hold as trustee for the benefit of the beneficiaries, and you're doing this while you're alive, it means that you've given the property to somebody else. Now, if you've taken that step to give your property to somebody else, because it's been held on trust, you may still be concerned about retaining a certain level of control. And what I had, mentioned earlier is that, and Ken can speak to this as to, to what extent it's possible to for the settlor to reserve control in the context of a Henson trust that he will discuss in detail. But from our perspective, there are different mechanisms that you can do from a Barbados law perspective in a Barbados trust to maintain that control. You can first of all, you have your letter of wishes, which is basically non-binding guidance that you give to the person who is appointed as trustee as to how they are to distribute or manage the assets if the property is held on the terms of a discretionary trust. You can also have someone in the trust arrangement who is called a protector. And the protector operates like a supervisor or a watchdog, and you can craft the instrument so that it's not possible for the trustee to exercise certain specified powers without the consent of the protector. So any purported exercise by the trustee of those powers without the consent of the protector, where that consent is required, would be an invalid exercise of that power. Under our laws, it's also possible for the settlor to reserve certain powers to themselves, including the power to revoke the trust, the power to give certain directions in relation to the purchase, holding, or sale of the trust property, and various other specific powers that our statute contemplates the settlor being able to keep for himself or herself. So notwithstanding that, the settlor, and remember, we discussed the different parties in the, the play of the trust, as it were. The settlor, let's go back to terminology, the settlor is the person who is creating the trust in the context of a trust that you're creating while you're alive. So the settlor is the person that transfers the property to the trustee, who is the person who is holding the property on the terms of the trust for the benefit of the beneficiaries. So the settlor, who is the person that has created the trust and who has transferred property to the trustee, can, under our laws, reserve certain powers specifically to himself or herself in relation to the management or dealings with that trust property. And you may say to yourself, so, okay, hang on, I'm supposed to transfer all of my hard-earned assets to some random person, and it's going to be their name, like, this is my piece of land, and I'm transferring my land to, John or Jane Doe or, X trust company. How can I be sure that they're going to abide by the terms of this instrument and do what they're supposed to do. So we discussed certain mechanisms before that can be put in place to ensure that you can have oversight and control, for example, in appointing a protector, so that there's no valid exercise of certain powers without the consent of that protector. But there is a rich and deep body of law that supports the concept of the trust. And at its heart, a trust is an obligation owed by a trustee to a beneficiary. And the trustee is actually what we call a fiduciary. And a fiduciary is a person who has a duty of care. And the law, very, very, detailed, case law, which sets out the obligations that the trustee owes towards beneficiaries. And the obligation demands honesty, integrity, owner standards of care, and good faith. And the trustee must comply strictly with the terms of the trust instrument. And the trustee must act in the best interest of the beneficiaries at all times. If the trustee fails to act or exercise his or her powers or its powers in accordance with the terms of the trust, or acts in a manner which is not in the best interest of the beneficiaries, the trustee would then be acting in breach of trust. And there is, as I say, a rich body of law which actually supports the oversight and the opportunity by the court to step in and to hold the trustee to account, or sorry, for the beneficiaries to hold the trustee account by resorting to the judicial process. So basically the trustee can't do as he or she likes with trust property, and they must follow the terms of the trust instrument quite carefully and discharge their fiduciary duties properly. So that is a very, very quick canter through trust and estates planning.
It's a very detailed, dense piece of law, but we like it.
Yes, we certainly like it. We certainly like it. And with that, I would like to introduce our keynote speaker for this evening, who is Mr. Kenneth C. Pope. Mr. Pope is one of the most trusted advisors in Ontario, providing solutions to families with a family member with a disability. And his focus is to discuss with them putting in place Henson Trust, which will ensure that the child with a disability will not be penalized for their inheritance, whilst receiving the security and financial stability which their guardians or parents have planned for them. His estate planning consideration is to ensure that his clients, no matter what their income level, will be able to plan effectively for their future and for that of their family members. With over 30 years of experience, Mr. Pope's clients benefit from his knowledge and foresight. His practice has become a one-stop shop for families living with special needs across Ontario, offering telephone and video conferencing for those living further away. He and his team host free webinars throughout the year, offering free advice and answers to the questions of parents all over Ontario. He's been able to help families think through their future needs and to plan for themselves and put in place appropriate arrangements. His focus is on making tailor-made solutions and payment plans so that his clients can take care of their most important responsibilities and enjoy peace of mind. His knowledge and experience with estate planning offers his clients the full range of financial options, which will protect the inheritance and ODSP benefits of a child with a disability. And with that, I'd like to hand over to Ken.
Thank you. Thank you very much, Tara.
You're most welcome.
You just saved me a lot of questions and answers. Zoom in a little bit here. This is the prerogative you have when you're the keynote speaker, such as I am. There you go. And I'd like to invite all the people that are watching today to take off their masks as well. We have 38 people registered. 38 people registered, and we have, let's just see, is that a 21? Yeah, we have 21 people taking part, which is about average. We find that we get about half, slightly over half of people that register attending. So this is pretty normal. And I'd like to welcome you all. I'd also like to thank Frank especially. What he had to say is exactly on point. The question is, what will happen to my child when I'm gone? You know, I had one mother tell me that she'd like to live just one day longer than her daughter. And that's exactly how it works. And I think that the people that lawyers and professionals, supporting professionals and social workers, and you know, these people need to learn a little bit of humility. Not that they're overbearing, but they have to remember that it's the families that have the commitment in this game. They have skin in the game. And the way I describe it in my seminars, if you were to look at a family with a child with special needs, and you compare the supporting professionals and the family, and you put it in the context of an egg and bacon breakfast, the chicken's involved, but the pig's committed. And that's what it comes down to. So, you know, we try to do the best we can to provide peace of mind. That's really what we do. We just provide peace of mind in the form of wills and trust provisions and legal guardianship and certain access to certain benefits and a certain number of years of experience. Everyone who's registered will receive a recording of this and the PowerPoint slides. And you'll be put onto a subscription list, a mailing list. You can unsubscribe, obviously, but there's over 13,000 people on that list. And we do regular webcasts and email blasts that, of course, mostly will apply, you know, to certain things in Ontario, Canada. But the dynamic of the family and their children is just the same here. Now, I'd like to move forward to a couple of slides, and I'll try to be quick, because the concepts here are well known to all of you. So I have to get my little arrows. Now, yeah, this doesn't work now. Sorry? Okay, all right. So just click on it. Sorry? Oh, okay. Okay, good, thank you. This is my son Gregory, he's my technical support. He also just happens to get a trip to Barbados. So what we're looking forward to finding out, Frank and I had a little chat about this the other day, is I won't go into detail here, but you'll get these slides. But what it comes down to in Ontario, which has a population of this side of 14 million, is that if you divide the number of people by 3, Statistics Canada says that tells you roughly how many households there are. Now, that may or may not be the same in Barbados, but I think it's probably a rough estimation, right? So that means that you have a third of the total population are the number of households. And in Ontario, broken down by city, 1 family in 10 is a family with a child with special needs, which is significant. So if you if you round up, as far as I understand, if you round up the population of Barbados to 300,000, that gives you 100,000 households, and that would give you 10,000 households with a child with special needs. So I'm really looking forward to finding out if this is true, but so far I don't see any reason it won't be comparable. But even let's just say that I'm completely wrong and it's only half. Let's say, well, it's 10,000 people, 5,000 people, sorry. I think that there's a time and a place to try to improve circumstances for 5,000 families. I think that's a reasonable objective. So that's what we hope to do. This is the breakdown by categories of types of disabilities and special needs in Ontario. And again, you'll get this. You don't need to look at this. This is the breakdown of the number of people 18 to 65 who are receiving provincial disability benefits, which are either $8.96 a month, Canadian $8.96, or $11.69 plus drug and dental. And what I'm looking forward to finding out is whether there are any kinds of benefits for adult people with special needs who couldn't function in a competitive workplace, or couldn't function in the community, or couldn't handle personal care. And where we're going to get those numbers, I don't know, but you'll help me. These are the benefits in Ontario. These are certain tax credits, disability and caregiver credits. There's a credit that applies to somebody with a disability. It has to be marked and severe and prolonged. But of the families I'm working with, that applies to about 50% of them. And then there's a caregiver credit, which is a tax credit for the caregiver, the parent. And these credits are available if you pay taxes and if you pay enough taxes. So for example, in the case of an adult with a disability who qualifies for the disability tax credit, it would, if they paid taxes, or if they don't, if their parent pays taxes, they would save $1,600 a year, okay? And for the caregiver credit, it reduces the taxes of the tax-paying parent by about $1,000 a year. These are the criteria for whether you would qualify for the provincial benefits. And this is the criteria for applying for the disability tax credit. Now, you're having an election tomorrow. And as a result, I'm not sure, I doubt that the open bar at the Barbados Beach Club will be open now. Perhaps, does it open after voting's over, do you think?
I have no idea.
It does, oh, good, okay, thank goodness. 6:15. Let's hear it for Banks Beer. So just at this moment, I especially like to thank the Barbados Beach Club, and in particular, Kim Hudson. Kim is the sales manager there. And she was kind enough to gratuitously offer us a room to do this presentation from. I thought that I might have other staff members that they're all down here. Staff members taking part from there, but I decided not to do that. But I'd like to thank Kim in particular in any event. Thank you, Kim. And also, it's a great place. This is just information about the caregiver tax credit. So the reason I mentioned the election is that which party has this plank on their platform? Which party?
Well, I can comment the BLP in the manifesto published over the weekend with the number 9 on it, I think it was, or page 9, explained that it would be their policy if they would return to government to put more emphasis on looking after and making provision for the disabled community. There were about 12 ticks or 12 lines of action which they said that they would incorporate into the new policies. I can't tell you straight away whether people have been offered caregiver tax credits and measures like that, but I do not recall that particular offer to the electorate.
Thanks, Frank. I don't wish to be partisan here. I just want profile for people with families with kids with special needs. Now, in Canada, it's fairly recent, since 2008, we have a thing called a registered disability savings plan. And if a child is 18 or over, I'll just tell you the simple story. If a child is 18 or over and is unemployed, of course, can't function in the competitive workplace, then they have, the only income they have is the $896 a month or the $1169 a month, which is about 14,400 Canadian. And at that income level, if they set one of these registered disability savings plans up, then if the family contributes, if someone contributes $1,500 a year, the federal government contributes $1,000 bond and $3,500 in grants. So $4,500 a year. And as you'll see when we get to the next slides, if you start out with contributing $1,500 a year and getting $4,500, and if you contribute for 20 years, which is the limit, and then you keep it invested all of that time, and you leave it invested after the last grants and bonds are contributed, then if it's invested at 5%, by the time the child is 60, it's $700,000. Now, that's the power of compound interest or compound growth, right? So, but these are specific savings plans. And the point I want to make just at this point, aside from this wonderful plan, which people with disabilities never had before, is that it's their property. So if they're competent, they can manage it themselves, or they can sign a power of attorney to have people help them to manage it. But if they're not competent, well, then it's their property. So when they first started out in 2008, if you weren't competent, which is 50% of my clients' kids, they couldn't have one of these things. So we started doing legal guardianship. So the parents could be the legal guardian of the child's property. And then they eventually, a few years later, they decided to let parents be the account holders for a not competent child. But it's still, that's the limit of it. So when the parents are deceased, as it is now, there's no one else who can manage, invest, and handle the disbursements at age 60 from these $700,000 savings plans. So we've been doing legal guardianships since 2009. And that's just the way the firm has developed. I was called in 80. I started this particular practice in 1996, February 26th of 1996, actually. And in 2009, we started doing guardianships. And that's the way it's been all the time. You just gradually add skills and services to help to dig that, fill that niche, which is a very, very deep niche. Now, this is just more about RDSPs. You'll see this when you get the slides. This is the growth at investment at 5%. And those are just things you don't need to know about. This is taking control. What's the difference between legal guardianship and powers of attorney? Diane, would it work for you to speak to this? Perhaps you and Tara to talk about powers of attorney. Yeah, you can turn that in. I mean, I'd like to introduce you to Diane Verano, my associate at the office. Diane You'd like to speak as well about powers of attorney in Barbados, because what I heard you say was that you don't have continuing powers of attorney. Okay.
We just need to go back. Yeah. Okay, zooming up slowly but surely. Okay. Okay. Hello. I'm fine. So my name is Diane and I work in Ottawa with Ken Pope. And I do a lot of guardianships, and I'll tell you, most of our clients, they come to us because their child, who's an adult, cannot do a power of attorney. So our first choice to appoint a substitute decision maker for a child that can't make decisions for themselves is to see if they can execute a power of attorney. If that's not possible, then we will proceed with guardianship. And in Canada, there are multiple ways to get guardianship. The way that we do it is through the court. It's an application that goes to court. It's about 200 pages long. So a lot of paperwork. It involves affidavits from the applicants, and it involves two plans. One is a management plan to explain to the judge what we plan to do with the child's finances after guardianship is received. So what do we plan to do with their disability benefits, which most of the time is pretty straightforward. Most of the time the applicants are the parents, and they're just going to keep doing what they've always been doing, even after guardianship is granted, which is use the provincial disability benefits for the child's needs. The other plan is called the Guardianship Plan, and this is a plan that the applicants put together, which explains what they want to do in terms of healthcare decisions for their child. So whether it's making sure the child is fed and the nutrition is kept after, and that they go to all their doctor's appointments. So it's pretty straightforward because, like I said, the applicants are usually the parents, and they've been taking care of this individual since birth. And the difference with guardianship, well, one of the main differences between guardianship and power of attorney is with guardianship, we do have to put evidence of the allegedly incapable person's capacity. So what that means is we book capacity assessor appointments. So they're called capacity assessors. They meet with the adult child with disabilities, and they ask them questions about how they, how they take care of themselves, how they take care of their finances, and then they write a report. And this report will, in their opinion, make a judgment on whether or not this person has capacity to manage their own health care or their property. If the capacity assessment shows that this person cannot take care of themselves, then we're going to include it in the guardianship application. Like I said, it's a pretty thick booklet, about 120 to 200 pages long. This goes to the judge. Another copy will also go to an organization called the Public Guardian and Trustee Office. And what they do is they read that application with a fine-tooth comb and just make sure that whoever is applying has the best interest of that person in mind. In Canada, it can take months, maybe at least 6 months for that process.
Yeah, no, I just wanted to kind of, reiterate what I had shared earlier in the context of powers of attorney, because I think many persons in our audience may have heard of an enduring or a lasting power of attorney or a durable power of attorney, which, some iteration or version of that exists, in the UK and in Canada, I believe, as well, and also in certain states in the US. But we don't actually have that facility under our laws because our laws still follow the traditional position. So our laws derive substantially from English common law. And the default position or the historical position was that the death or incapacity of the donor, so the person who creates a power of attorney. So people will want to use a power of attorney in the context of estate planning because, they're saying that if I'm incapacitated, this person, will be able to deal with my property and affairs and arrange things for me, and also in the context of death as well. But from a traditional perspective, English common law perspective, the death or incapacity of the donor, the person who creates the power of attorney and who confers that power on the donee, the death or incapacity of that person revokes the power of attorney, because the donee of the power of attorney is effectively an agent of the donor, who is the principal, and the agent can't be seen to have any more power than the donor himself or herself has. And if that person has died or is no longer compos mentis, or they're mentally incapacitated, then the traditional position in law is that their death or incapacity would revoke that power of attorney. That traditional position has been altered by statute in the UK, and other jurisdictions, but we haven't as yet kept pace with developments in other parts of the world, in Barbados, where that is concerned. So what it means is that, when someone, for example, becomes incapacitated, mentally incapacitated, you need to actually make an application to appoint a receiver under the Mental Health Act. It's, a fairly involved process and can take a significant period of time. And you actually have to file supporting documents to show the bona fides and the fitness of the person who proposes to be appointed to take care of the affairs of that incapacitated person.
Good, thank you.
Okay, if I can ask a question on that. You're saying that if the person who is granted the power of attorney dies, then everything's revoked. Okay, so under Barbados law currently, then what happens at that point? I mean, apart from having to apply the courts for receivership and so on and so forth, which can take an awful long time. Now, what happens in that time span between that person dying and 6 or 12 months later? I've heard receivership can go on for a long time. So what happens to the person who needs looking after?
That's an excellent question, Frank. It's an unfortunate reality. You hit the nail on the head, and I think it underscores the urgency of this issue. And it's not a difficult thing for us to change in law to be able to address these types of issues. Currently, in terms of the care of that person, they are effectively left to the goodwill of their relatives and family. Yeah, so they're left to the goodwill of their relatives and family who, you would hope, God willing, that you have at least one family member who has your best interest at heart and who also, has access to resources to help take care of you.
But in effect, it's as though you would have not taken out a power of attorney agreement in the first place.
Correct.
You go back and square one.
Correct. Because mental incapacity actually in Barbados revokes a power of attorney.
I'm sure that will be addressed, and that's part of the reason for all of these discussions, obviously. Now, the reason that we apply for legal guardianship in advance while the parents are alive is for, during the parents' lives, things often run smoothly. They get relative cooperation from medical authorities and hospitals, and the provincial benefits that are received are given over to the parent as trustee. There's no muss and fuss about this. They can be the account holder on the RDSP. So, as we explain it to the families, you're going to be fine now. It's just that one day, the way I describe it, you're going to get to be that awkward age where you're not old and you're not likely to die soon, probably, but you understand mortality. Now, the applications that Diane brings, there is a lot of paper. It does take some months, but of course, right now, there's no crisis in most of our cases, and she does all the work. So all you have to do basically is tell your story, help with the affidavits, sign here, thank you very much. And she files it with the court. And there are no court appearances for you because it's a bucket application. And they're all granted in our case in the Ottawa courthouse because it's the jurisdiction of the Superior Court. It's not based upon your residence. So, there may be some difference here in Barbados, but what it sounds like so far to me is that if you have these 50% of people with disabilities who are not competent, let's just say that's the number, that your application for receivers would be again, the preemptive thing to do before the parents die, because that's when you have issues. I mean, maybe there are issues now, and then of course you deal with it now, obviously. And you can have situations where people become not competent, as they age. And so again, you're going to either have to fix the continuing power of attorney problem for people that are normally competent or deemed to be competent. But from my practice perspective, it doesn't change anything because these kids aren't competent now, right? So it's really just a question of, do you want to leave it to whomever comes after you to deal with this issue so that there's someone who, just as you've arranged to have continued financial support for the child, can deal with the care of the child, both physically and financially for their assets, such as they may be. And if you don't, it may be that in cases where, this is the interesting part for me, if there are no real equivalent disability benefits, which is what I understand so far, then an inheritance could be left directly to a child, because in Ontario, if they inherited an asset greater than 140,000, let's say $140,000, they would be disqualified from the provincial disability benefits, which is a substantial problem. But you could either set up here, what I see so far is that you could either set up a trust to take the share of an inheritance that you leave for that child, and this is probably the simplest for that purpose, a trust that would receive the share that you're going to leave for that child You'd appoint a trustee, one of their siblings perhaps, or for now, perhaps your brother, the uncle for now, but of course they're your age. Or you could leave the money directly to the child if you have a guardian in place. Because if receiving that inheritance in Barbados doesn't disqualify them from anything, then the guardian, as long as they live long enough, could manage the money to receive directly as an inheritance. So for me, this is the fascinating part. What are we going to do here? What's the best plan here? You'll see these later. These are powers of attorney. This is about substitute decision makers. In Canada, we have provincial legislation in each province that if a person, a child becomes an adult and they're not competent, then the parent, and there's a line of parties who can be the substitute decision maker for that party. Types of guardianship, property and person. This is pension planning. In Canada, there are certain provincial pensions for employees that would pass on first to their spouse and then to their child with special needs, their adult dependent child. Now, if you can negotiate pensions, you could negotiate that kind of benefit. But of course, in most actuarial situations, this would result in a reduced pension at the start for the parent and the second parent in order to leave a pension for the adult dependent child. But you can negotiate for anything. Now, this brings us to Henson Trust. It's named after Mr. Henson, who died back in 1985. And I won't at present go into that longer story. But the trust that was set up in his will for his daughter, leaving her back in 85, $82,000, with the residue of it after she died going to charity dealing with her supports. That $82,000 back in 85 would have disqualified her from provincial disability benefits. So when Mr. Henson died, the trust in his will, which a fellow named George Gates in Guelph, Ontario, put together, who also had a daughter with special needs, which was a precedent that he'd gotten from another guy who had a daughter with disabilities that he'd met at Osgoode Hall Law School for a continuing ed event that he had, and he worked for the Catholic Church. So what happened here is, just as you mentioned, it was medieval and holy orders based about poverty. This guy worked for the Catholic Church. He gave the precedent to George. I met George before he died a few years ago. Nice guy. And he did this trust for Mr. Henson, not knowing if it would work. So it did, but it took a few years to have that settled. It was, I won't go into that story as well, but it took from 85 to 89 to have this settled. And so now in Ontario, and it would work here. This is a particular type of trust, which, because it's necessary, is an ironclad trust. So we may not have to build the armor quite as thick in Barbados, it's possible, but this is the most ironclad type of trust. And what it does is it gives the trustee absolute and unfettered discretion. So you can see that, for example, suppose you had a child with mental health issues. You couldn't leave him money because it'd be gone tomorrow. Or perhaps a child who has a drug addiction, just for example, or who is a spendthrift, or who has a wife who's a spendthrift, right? Well, you have to protect them from themselves. So what you have to have it set up so that there's an absolute and unfettered discretion, and the trustee can absolutely not disperse if in their discretion they don't want to. Now, obviously, the flip side of this is that you have to have the right trustees, or trustee or trustees, right? And there's always a potential possible built-in conflict of interest, because of course, typically, the residue of the trust when the child dies goes to their siblings. And most commonly, the siblings are the trustees because they're the same age, right? So, but in most cases, what happens is the parents are sitting in front of me in one way or the other, and I point this out to them. And they do one of two things. There's really only two choices. They look at each other because they know their children, right? And they look at each other and they sort of nod at each other for a second. And the one says, no, no, Mary will take care of Johnny. Or the ones that say, I guess I should add cousin Charles. Right? But this is just the natural part of this whole process. And the shall not vest part, this is a rebuttal of a standard common law rule. And that is that in a trust, because you have a life beneficiary and a residual beneficiary, when the child dies, somebody gets it, right? And these trusts could go on for generations if you wanted to. We won't go into that. Tara can do that in more detail at another time. But typically what happens is you leave, for example, an equal share of your estate for each of the three kids, whatever amount that happens to be. Perhaps you augment, and we'll get into this in a second, perhaps you augment the trust for the child with special needs with some life insurance designated to that trust, because you love each of your kids the same. It's just that you've had to pay attention to the one child more all of your life. And you can't be blind to the fact that the other kids know that, right? That you were always preoccupied with your son. So you have to be delicate with these matters. And what this does is it rebuts the common law rule that you have to have, the trustee has to have what's called an even hand, whatever the hell this is, a reversal of the even hand. That the non-vesting rebuts the beneficial ownership of the beneficiary. So they do not have a beneficial ownership interest. It doesn't vest in somebody until it goes to the residual beneficiaries. So they have no legal claim, right? There's an absolute discretion and no legal claim. That's it.
So it's a purely discretionary trust.
That's right. So there's just no two ways about this. It's not the kid's asset. There's no beneficial interest. It's not his, right? And the trustee has an unfettered discretion as to what to do with it. But the reversal of the even-handed rule, common law rule, is that the trustee, God love him, has to have an even hand somehow, what that is, between the beneficiary and whoever comes last. Well, how are you going to do that in practice? And in practice, of course, what you want is that if it takes the last penny to provide for your child with disabilities, that's what you want to happen. Because when you leave the other 2/3 shares to the other two kids, they get to blow all of that, right? It's not expected that whatever they've got, they have to give back to their brother. It's for their children. So anyway, the size of the trust is unlimited. It can hold any assets that you want, money, investments, stocks, properties, anything at all. And there are no limits to what can be dispersed from it, subject to the letter of wishes and the considerations of the deceased testator. Testator is the deceased party who did the last testament. And these are all testamentary trusts. These are not inter vivas trusts. You can do inter vivas trusts, but normally you have to be in a position where you have assets sufficient that you either presently can settle them on the trust and have some advantage to this, such as tax savings, or that at the very least you can lend them to the trust so that the income earned is taxed in the hands of the beneficiary who otherwise has no income and not in your hands. If you're going to take care of a child, it's better to pay in tax money in income that is not taxed compared to money that is taxed in your hands first and then taxed again when you spend it for your child. I don't think we need to belabor that point. I won't go into this right now, but in Canada, we have registered retirement savings plans. If you set up the plan and you contribute $1, you don't pay the tax on that $1, save the tax payment on that $1 until you take it back out.
We used to have that in Barbados.
Yeah.
But we no longer have that. That used to be a tax relief.
I see.
Can I ask a quick question
Sure.
before you go on? I know you,
No, go ahead.
I don't interrupt your flow.
Don't worry about it.
We talk a lot about the Canadian aspect of Canadian law and with reference to your history of practice and so on. And we have the Barbadian representative here of our local law. And I know we've got our local law related to English common law when it came across a long time ago. Here's the question. What is the connection or the reference or the effectiveness between what you're saying for Canadians and for us as Barbadians. In other words, I'm listening to you very intently, and I can see these practices on laws and laws passed, the whole understanding from a Canadian point of view. But what is the relevance for us here as Barbadians?
Well, there's two aspects of it that we're going to find. Let me speak to this for a second. Excuse me. There's two aspects, and they're the same in Canada and Barbados. In Ontario and Canada, one main reason that you need these types of trusts is so that the asset is not directly in the hands of the party who is receiving provincial benefits. So far, I don't see that that's an issue here. So far, what I see is that you could leave $1 million to some kid who's autistic, right? And he wouldn't lose any other benefits from it. Now, if that's true, and that's what I want to know for sure, if that is true, well, then you don't need the trust to protect them from losing other benefits, right? So that brings us back to the commonality of, should the money be received directly by that person, or should it be in a trust to be managed by someone else for good reasons, or are they simply unable to manage it?
So I think if I can just add to that, I can probably add some color to that question, Frank. That's a very good question, and I think Ken has, also really hit the nail on the head there. The Henson Trust, as I understand it, Ken, arose in Ontario, Canada, in response to a particular need, which was to ensure that disabled persons weren't made ineligible to receive certain provincial benefits because they were entitled to assets, significant amount of assets in their family estate. So because it's actually a response to a particular sanitary issue, and we don't have that issue in our jurisdiction, it means that that limitation and the way that that trust would need to be crafted with those particular provisions wouldn't apply here. So you have greater flexibility in creating a trust here. But it goes back to the fundamental and important point that you should be thinking about estate planning for your disabled beneficiaries or minors and so forth, and that something like a trust would be useful in that context. The Henson Trust, which Ken has spoken about, is a particular response to the constraints that would otherwise apply under Ontario law to be able to access benefits, provincial benefits, and at the same time access assets that would be available to that disabled person, family assets. So we don't have that as an issue per se. So it means that you actually have more flexibility in terms of how you create that trust, but still fundamentally, the trust is a helpful and useful instrument for taking care of those dependents.
Yeah. I think it'll help if you know more about Audrey. Audrey, Mr. Henson's daughter, she would have lost benefits, but besides that, she had Down syndrome. Right, she couldn't receive and manage an inheritance. And you could say to yourself, okay, well, I'll leave it to her sister. Well, I won't go into all the things that could complicate that factor. So Audrey would have needed a basic trust anyway. She can't receive an inheritance. Now this is just a little speaking piece. It's 8:15. We're doing pretty good. 6:30, 7:30. We'll have to wrap it up fairly soon though. Do we have any questions coming in? Okay. That's all right. I just wanted to see if there were stuff to be moderated. So I'll be done very quickly here. If you want to supplement a trust, because your estate is modest, most people have a modest estate when they're young and have kids. What you could do is you could buy some life insurance. I wouldn't recommend term because term gets more expensive as you age, and it's by term, by definition, it means it's for a certain period. So I wouldn't go with term, but you could in the short term. You could think about this, but the issues that we're trying to deal with are not ones that are temporary or going to disappear. So you'd look at long-term insurance with a fixed premium. And just as an example here, if you take a female age 50, she's not non-smoker, her life expectancy is 35 more years on the actuarial chart. If you get a universal life policy for $100,000, the premium is $115 a month roughly in Ontario. That's $1,384 a year. So something over 115, a little over $100 a month. Now, the way it works is this: if you tried to save that premium, the $1,384, you'd have to, if you wanted $100,000, you'd have to save it for 72 years. Now, I realize this is simplistic and there could be interest and all that, right? Got that. But you can see that if you just tried to save this money and you put it in some safe, secure place with a little bit of interest, then you're supposed to live 35 years, but you have to do it for 72 years. So, you know, if you think that you might want to supplement your trust, you should get some quotes for this kind of thing. And you simply designate it to the trustee of the trust for the child. The child receives whatever share of the estate, which is modest, but something more than $1. And even if there wasn't $1, you could still fund it with the insurance. It would still, at least in Ontario, it would still be a testamentary trust. And here is where we get to questions. Diane, would you like to moderate?
Yes, we have a question from Denise, and I'm thinking maybe Tara can answer this question. And she says, in Barbados, what happens to the trust for the beneficiary who might be disabled if the trustee dies soon after the settlor?
So let me start off by congratulating Denise for being the first person to very bravely put forward a question. We're very happy to encourage participation. So Denise is basically asking the question of what happens if the trustee dies soon after the settlor. So they have set up a trust, but the trustee dies. Typically, most well-drafted trust instrument, whether it's an inter vivus trust, i.e. a trust which is established when a settlor is alive, or a testamentary trust, which can refer to otherwise known as a will trust, which takes effect on the death of the person who's actually creating the will trust. What happens if that trustee dies shortly thereafter? Most well-drafted trust instruments will actually include provisions that deal with succession to the office of trustee. So that's pretty standard. But if the trust instrument itself or the testamentary trust instrument does not include provisions which deals with succession to the office of the trustee, then you fall back on the Trustee Act, you fall back on the statute. And the Trustee Act includes very clear provisions that specify that the person who's identified in the trust instrument as having the power to appoint new trustees, or if there's no such person, the surviving or continuing trustee. So if you have maybe 3 trustees appointed, the last trustee, the surviving or continuing trustee, would have the power to appoint a replacement. Or if that person has died, the personal representative of the surviving or continuing trustee. So the law is basically creating an order of succession of persons that it would fall to be able to appoint the replacement trustee. So repeating that, the instrument itself would typically, if it's properly drafted, include provisions that deal with changes to the office of trustees. If a trustee dies, if a trustee becomes incompetent, if a trustee wishes to retire or be discharged, and if the trust instrument does not include those specific provisions, then you'd have to look to the statute, the Trustee Act, which creates a mechanism for dealing with that. And ultimately, if you go down the entire line of persons who would have the power to appoint a replacement trustee, it would basically fall to the personal representative of the last surviving or continuing trustee. So if that trustee died before the settlor, and they were the last or surviving continuing trustee, and it didn't include any provisions for anyone else to be appointed, the person who is their personal representative, i.e. their executor or their administrator of their estate, would be entitled to appoint the replacement trustee. And if all else fails, you can actually make an application to the court. Yes, so Frank, if you can have more than one trustee?
Well, if you appoint.
Yes,
a
yes,
trustee,
yes.
If you appoint, let's say,
Yes,
3,
yes, yes.
which covers covers your risk as wide as possible.
Excellent point. That's also a good point. So here is Frank engaging in lateral thinking, because I didn't actually think that way, but that's a very good way to deal with that issue as well, which is to appoint more than one trustee, so that you know, in the unforeseen event that one of them dies, there is someone else who can actually fill that role immediately without having to go through a waterfall provision in the instrument, or looking to the statute, or making an application to the court.
Doesn't that make the settler as well? I think it's the right word. Doesn't it, or rather, the person who grants the trustee, doesn't that make them feel more comfortable?
Absolutely,
The risk is dispersed?
absolutely. Oh, you're A plus, Frank. So there's the other angle of what he just shared there, which is that not only will appointing more than one trustee help to deal with issues arising from like succession to the office of trustee, but you basically have, you know, a check and balance in place. So all of the power related to the trust is not put in the hands of one person as the trustee. You know, it's basically shared amongst more than one person's 2 or 3 trustees, and you know, the trustees would basically have to act you know, jointly and make their decisions together. So one trustee couldn't go off on a frolic of their own and decide to, you know, dissipate the trust assets, you know, in a irresponsible manner. Do we have any other questions?
How can people contact you after the fact?
We can be contacted at my email address is tara, T-A-R-A .frater@ftlegal.com. Yes, we should have had something about this.
Hold up one of your cards.
You don't have any on one of my cards. If you just Google Tara Frater, my name is TARAFRATER, you'll find our website, you'll find our contact information, you'll find everything that you need to know in order to make contact with us. And also, if you contact Ken, and Ken's information is right there as well, Ken has our contact information.
Yeah, we're going to collaborate.
If I can ask another question. As Barbados has developed over the past 40, 50 years, especially since independence, are people becoming more aware that you can take these, or they can take these measures now to protect their families in the event of their death? Is it becoming more and more a custom, or is it still an unusual event?
It's unfortunately, I think, somewhat of an unusual occurrence. Most people, I think, are aware of the importance of making a will as the entry-level point for estate planning. But I wouldn't say that, because like the Henson Trust that, you know, Ken has so kindly shared information with us about is a testamentary trust, or it's a will trust. So it's a trust that's, you know, included in an actual will or a testamentary trust instrument. And I'm not sure that many people know that they can actually do that with a will. They think that their will is just basically to say, you know, this account to that person, this piece of land to that person, end of story. And the majority of wills are purely dispositive. They purely distribute assets, and they may or may not deal with issues dealing with guardianship or disposal of the remains of a person. But you can actually have your will deal with or create a trust to take care of disabled persons and, you know, or persons, you know, who need to be looked after.
In Ontario, if you look at the numbers, you look at the whole spectrum of adult people, simplistically, about 50% don't have a will. Of course, those numbers change to some degree as people get older. But then if you look at we have all these statistics, we have garnered the statistics from 13,000 families now. So when you merge and purge all those numbers, we have a pretty clear handle on just what families look like. And of the people that do have wills, whatever that number is, but say it's in an older age bracket, let's say it's 80%, let's say. What we find is that the number of people that do have trust provisions for the kids on this specific family profile It's very, very few. It's just unknown. And that's after me going around the province, physically doing on-site seminars from 96 until 2015. And then having.
So you're basically an evangelist for this very important issue.
Basically.
Yeah.
Now I don't travel as much, you know, I'm now retired, I ain't done it. So, so to speak. And what it comes down to is there's a big job ahead. So whether it's 5,000 families or 10,000 families, it's 5,000 families or it's 10,000 families that need to be assisted. And they need to decide whether they want to be assisted or not. If they do, they should be assisted. That's what all this comes down to. So this particular session, this is the second little get-together that Tara and I and others have had. We had a sort of a proof of concept get-together in January 2020. I contacted Tara because she as she mentioned, she belongs to the Society of Trustee and State Practitioners Society. So I just looked at the Barbados step chapter and contacted a few people. The local bar, I think local bar both in 2020 and this year, has been very supportive, distributing the invitations to the bar as a form of continuing ed for them. And we're just going to keep going. This particular event, get together, is the feasibility session. Does anybody sign up to take part? Does anybody actually follow through? What are the real what's the on the ground situation in Barbados, right? And that's what this session is about. So we'll just carry on.
Well, if I can just say, that's one of the problems that we haven't in Barbados. We don't have the metrics to discuss and to put forward to anybody, really, whether it's anybody in government ministers or anybody else. Nobody knows for sure just how many disabled people there are. The BCD as an umbrella organization has about 20 organizations beneath it, as it were. And we reckon that, roughly speaking, that there could be about 11,000 people in Barbados who are disabled to one degree or the other, whether it's physical or intellectually challenged. That also includes people who are blind or deaf, who occupy wheelchairs for much of their life, and so on and so forth. And in fact, if anything, the good that's come out of the COVID pandemic over the past almost 2 years now, it has highlighted the fact that the ordinary abled person has suddenly realized that there are a group of people out there who are stuck at home all the time, and they have suddenly joined the world of the disabled. So in a way, it's made people aware of what is going on all of the time, that they think they can merrily drive down the highway and act out a normal existence as anybody would in a developing country or a more developed country. So the other advantages given people as well is that they now are aware that they can work at home behind the computer. And being behind a computer, as the story goes, nobody knows that you're disabled. So there are certain advantages there, and I think the BCD will be pushing these discussions with the new government, whoever it is, in the following months. I know that Kerry, our president, has already asked for, as I understand it, a meeting with the Minister of Health and Minister of Education as well, because we fall into both camps. Thank you.
Well, I think we should wrap it up for now. Is there another question? We have 4 more minutes.
So this, we have another question, and I guess I'll ask Tara and Ken, because we get this question a lot as well in Ontario. And the question is, would the probate period unduly delay the implementation of a trust for a disabled child within a will? So I guess there's a will that has a trust for a disabled child, would the probate period unduly delay the opening of that trust?
Sure, great. So that's a really valid question. And clearly the person who has asked that question has some sense of the pain that can often attends that process. Applying for a grant of probate is a slow process in Barbados and in many other parts of the world. It takes several months and it can take in excess of a year as well, unfortunately. And there is a bit of a backlog at the probate registry as well, which exacerbates that issue. So in terms of implementing a testamentary or will trust that includes provisions for the care of a dependent person, that needs to be done being cognizant of that practical challenge, and perhaps, you know, having some other, you know, practical measure, you know, having an account which, you know, having an account and having one or two persons that are trustworthy, you know, jointly hold or be entitled to that account so that that person can actually tap into funds to look after the disabled children during the period when an application for probate is being made. And can you also speak to other options as well?
Yeah, that's a very common everyday thing, a joint account of some amount. Because of course, when the parent or the second, especially when the second parent dies, often the child was receiving constant support of different sorts, and they all involved financial expense. So of course, the parent's gone, the child is maybe still living in the home that between the child and the aged parent, they could both get by better. So it was a logical thing to do. But now the parent's gone, the child's only friend, their mother, is dead. And there's still financial costs to keeping the child in the home, perhaps with supports. So yes, you set up a bank account if you're this fortunate, and you have a joint account with whoever is your executor or trustee, and you have to leave 50 grand in it or whatever. Or in addition, what you could do is you could again buy a modest life insurance policy, which is designated to the trustee of the Henson Trust in the will. But normally, once you have a proof of death and put in a claim form for the life insurance, you can often receive a check payable in trust to the trustee in 30 days. So if you plan for a 30-day period plus a kick-in for life insurance proceeds, that would work as well. This is all just part of estate planning. Now, I think that's about it. It's 8 o'clock on my phone. It's still, what is it, 6 minutes to 12 on the clock on the wall. It's been that way for a couple hours now. So I'd like to thank everyone for taking part. I'd like to thank all of my co-panelists and my associates and assistants. And we'll talk to you again soon. Good night.
Thank you. Bye.